Okay, so I'm going to talk to you about constitutional reform and talk about different models of constitutional reform. This is, as you know, it's a work in progress. I've given it twice and had some interesting feedback. It's due somewhere in a couple of months, so I'm looking for even more feedback. So I really do welcome your comments and criticisms. Okay, so populism, and particularly authoritarian populism, has in the past often been thought or characterized as being in opposition to constitutionalism. That is a practical matter. Many populists try to, work around the Constitution or oppose the Constitution, or even at a philosophical level, there's this idea that authoritarianism and constitutionalism are, in principle, in opposition. But what we've seen lately, a number of people have noticed that there are a number of regimes which can be described as populist authoritarian, and the regimes that I'm very specifically talking about, and actually I'm really only talking about these regimes in this paper, is Hungary, Poland, Turkey, and Venezuela. In these four cases, what you see very clearly is that there is a pursuit of an authoritarian populist agenda using constitutional reform as the means. So in all four of those cases, they are interested in engaging in constitutional reform, and also, I will argue, engaging in constitutional reform within some structure of what we might call liberal democratic constitutionalism. So this has come to be called, and I didn't make up this term, populist constitutionalism. So people like Jan Burl Mueller use this term, and Andrew Arado used this term, and a number of people, particularly Europeans talking about constitutional reform, use this term populist constitutionalism. So I'm interested in looking at this phenomenon, and I'm concerned. I see two dangers, and it's these two dangers that I want to try to articulate an answer to. So the first danger is that both the institutional innovations and the institutional things that are being done by populist constitutionalists, actually I'm going to turn this on just so I don't, as well as their rhetoric, justificatory rhetoric, separates liberalism from democracy. And so, and what they do is they kind of, they want the mantle of democracy for legitimacy purposes, but they want to try to extricate it from liberalism. And I think it's not just that I don't want liberalism and democracy to be taken apart. What I really want to claim is that they cannot claim the mantle of democracy. That is, I think that they are using a very problematic view of democracy. And so I'm interested in arguments to show not just that they are illiberal in what they are doing, but that this is undemocratic in what they're doing. And I think that this whole trying to separate liberalism and democracy is actually a very problematic, both at a conceptual and a practical matter, a problematic strategy. So that's the first danger I see in these movements of populist constitutionalism. And the second, and in some ways I'm more interested in this, but I'll probably talk maybe less about it, is that these regimes all use democratic institutional means to pursue their agendas. So they use referendums, they use electoral majorities, they use things like constituent assemblies, right? So these are all democratic institutions. And one of the things that I worry about is that they kind of give a bad name. So I am very interested in citizens participating in constitutional reform. I think constitutional reform should be a democratic process. I think there are ways of using referendums in constitutional reform. There are ways of including citizens, including using majoritarian, particularly like referendums. So it's important to me that I show the difference between how the populists, I think, misuse referendums, for example, and the way they can be used in what I would call an authentically democratic constitutional reform. So those are my two kind of arguments that I want to flesh out in the paper. I do this, first of all, I start with a section on, what is populist constitutionalism. I lay it out a little briefly. And then I have this section which I really will go over very briefly because I haven't really figured it out yet, but it talks about the liberal constitutionalist response to it and this debate in the United States between liberal constitutionalism and what's sometimes called popular or democratic constitutionalism, and how this This debate really actually is not helpful in thinking about answers to populist constitutionalism, and part of why it's not helpful is that it reproduces this dichotomy between rights and democracy that I think is at the heart of the problem of populist constitutionalism in the first place. And so I end then with this defense of the idea of deliberative constitutionalism, also a term that's been united and made up. That lots of people, there's a couple of books out there that have just come out about this term deliberative constitutionalism. And I put forward that as an alternative. And at the end, what I will do is I will do concrete cases of citizen participation in constitutional reform and contrast them. So my cases are Ireland and Scotland and the use of referendums, citizen assemblies, and citizen participation in the constitutional reform in Ireland and Scotland, and compare it to these cases of Turkey and Hungary. So that's the quick overview. Okay, so what is populist constitutionalism? The first thing I think I really have to talk about is the term populism. You know, it's everywhere now, it's everywhere, and there are a lot of people saying, you know, it's overused, and that might be true. So I really want to start with a disclaimer. I am not offering a definition of populism. I am talking about a very, very particular kind of syndrome that certain regimes use. That is, it is a strategy of it is a strategy to consolidate power in these populist authoritarian regimes. So really the comparison is with other ways of doing constitutional reform. And I'm quite explicit that this is I consider this a pathology. And it has to do with the misuse of certain types of democratic justifications and democratic institutions. And as I say, I'm not claiming, for example, that these regimes are populist. I'm claiming that they might be, right? But my argument is that the strategies they use, I call it populist constitutionalism. And maybe I shouldn't, maybe I should call it authoritarian constitutionalism or something like that. The reason why I use the term populist is that at the heart of these claims, right, is a claim about speaking on behalf of the people. And it is an explicit claim about democracy and about, as a justification, and speaking on behalf of the people. So just the term authoritarian doesn't really capture it. And furthermore, it's not just a kind of superficial rhetorical claim to use democracy. I mean, Bernard Crick begins, he has that book, I think it's The Short Introduction to Democracy. He says, look, all these horrible regimes in history have, tried to claim to be democratic, right? So, the Democratic Republic of Korea. I mean, everybody. So it's not new that people try to, but there's a real difference when somebody like Orban claims to be using democracy to justify, because they are claiming to be working within a liberal democratic, all these regimes, even Venezuela, right, still has a constitutional court. So there is a claim to be working still within the framework of liberal democratic constitutionalism, and in all those four cases, they're claiming that they're just correcting it a little bit. That this balance between liberal democracy has just gone a little too far over towards liberalism, and they're bringing it back towards democracy. There really is this claim. It's not just, like using the word democracy. There is a more substantive claim, and I want to try to unpack that claim. So it is important that I refer to this term as populist constitutionalism. That's not, as I say, I don't really want to get into the problem of defining, so there can be, and the other thing is this strategy that I'm discussing, it's really a strategy of parties in power. It might be the case that opposition parties, they might have some rhetoric that would appear to actually imply that they would do this in power, but it is a strategy undertaken to consolidate power by certain parties. So it's I'm trying to be a very narrow view of a certain type of constitutional reform within generally liberal democracies. I mean, we can argue maybe Venezuela has gone too far now, but and so the term populist for me is important because of the centrality of the claim of speaking on behalf of the people as carriers. What is the claim? So here, actually, I very generally borrow from Jan Werner Müller, who I think actually, he does put forward a general definition of populism, and one might find this problematic because he really focuses on the anti-pluralism and not, say, on the anti-elitism of populism. But for my purposes, it actually is very good, his definition of the problematic view of the people, because in all four of these cases, or if you find similar cases, this is at the heart of the claim. So the three claims are that the populist regimes, the parties, right, they use this as justification. First, it's a claim to speak for an authoritative people. So there is a claim of popular sovereignty. It's not just moral. You're not just getting up there and saying, you're actually claiming in representing the people this gives you the authority to do things, pass laws, and so on and so forth, right? So that's the first claim. The second claim is to speak the truth on behalf of a unified authoritative people. So here you see a common across all four of these, but maybe different extent, is that there's opposition, dissent, and criticism really has no place. That opposition, dissent, and criticism, particularly in the public sphere, is understood as putting roadblocks up to obstruct the will of the people. So it's anti-pluralist. And three, it's the claim to speak exclusively on behalf of the unified authoritative people. So it's not just the general opposition to pluralism, it's the vilification of alternative perspectives that you see. And in this last, what you see is the rhetoric, the kind of the Schmittian rhetoric of friend-enemy in the public sphere, and you see this in all four of the cases. So I take this view of the people, and I look at really three dimensions of populist constitutionalism. The first is the rhetoric, and I have lots of examples. Let's see if this is a quote from Erdogan in 2017. He says, "The republic belongs to the people." Sorry, the republic belongs to the public, the people. Those people, when he talks about those people, he means the opposition. He goes, those people don't have respect for the people or popular sovereignty. Remember the slogan, one people, one flag, one homeland, one state. It's pretty clear, and in all four of these cases, there are great examples of the rhetoric in which they appeal to the people, and it's always a unified people. And opposition and dissent is described as being opposed to the people. The second component of these four, the second is that they all, it's interesting, Jan Werner Müller claims that in claiming to represent the people, the claim is really a moral claim, right? On behalf of these parties. And it's a moral claim because they have constructed a fictitious people, right, that they are representing. However, in addition to this moral claim and this fictitious unified, they almost always back it up with an empirical claim having to do with majorities, right? And so in all these cases, they have said, look, we won a majority of this election. We won this referendum. So they always have empirical claims backed up using appealing to the participation of citizens in some form of aggregative or electoral or majoritarian institution. And what's really interesting is that these two first components, that is the rhetoric, the justification is about the people, it's about democracy, it's about participation. The institutional means of electoral majorities and referendums is also all about citizens speaking and citizens acting and citizens participating. But the goal is always the consolidation of executive central power and the perpetuation of the party in power. So the goal is not itself the expansion of participation. Now, in some places, so for example in Turkey, right, part of the referendum was about bringing about a presidential system. Now, you might want to argue, well, you know, there could be a claim that a presidential system is directly elected by citizens, therefore it is enhancing participation. But it's not enhancing participation in any kind of significant or really meaningful way. And it's pretty clear that the interest in all four of these places, but in the enhancing of it's not really in citizen participation. It's in structuring the institutions such as to consolidate the central power of the executive. And in all these cases, top of the list of institutional reform is the limitation of the court. And of course, I want to argue that this is it's not just anti-liberal, this is an anti-democratic move. The limitation of the court vis-a-vis the way the courts can maintain and protect the public sphere, vis-a-vis the way the courts can oversee and have oversight over executive power. So there's this interesting kind of contradiction between the rhetoric and institutional means of democracy, but actually the institutional goals of reform, which is all the consolidation of executive power and the perpetuation of parties in power. This is like most clear in Venezuela, where you know, you might argue it's kind of gone so far that it's no longer a liberal democracy. But as I say, they still have a constitutional court, and like, you know, why not just get rid of the constitutional court? Instead, they have it. Can't really do much, and it's kind of packed with, you know, the party people. But they still want to have the kind of trappings of liberal democracy. Okay, so what's wrong with populist constitutionalism? So a kind of standard and intuitive way to approach this is to say, well, you know, I mean, why do you have courts? You have courts so you don't let majorities, you know, do what they want to do. You have courts to limit majorities and to protect individual rights and so on. So, and so there's a kind of standard liberal argument that says it's really bad to limit the courts, and it's even worse to actually make constitutions subject to majoritarian, you know. I mean, that sort of defeats the purpose of constitutionalism. If you can just have a referendum, 51% of the population gets to change your constitution. But the problem with that argument is that it kind of concedes the point. It says, look, you know, you have liberal limits to democracy. And democracy by itself, just majorities, is really pretty dangerous. And that's actually why you have, you know, constitutions. But that's exactly what all four of these regimes, but particularly because he's the most explicit, Orban is saying. Orban is saying, look, liberalism limits the will of the people, absolutely. And, you know, it's limited it so much that we have not actually been able to create a Hungarian state, which is really, you know, expresses the interests of the people. So that is the problem, you're right. So we want less of that kind of limitation. So this liberal argument just sets up a kind of the competition that they want. Right? Because it is premised on this idea that rights and democracy are in conflict with each other, and they're just going over to that side. So Orban can say, absolutely, he can say, look, because he says, look, you have liberal democracy, we want Christian democracy, you know, that's what we want, and these are just two different things, and you can't, you know, we know what liberal democracy is, but that's not what we want. And so this seems to me, this argument is just not very helpful at really, because in the end, it's just going to say, well, you got your way and we got our way, and it's not really going to challenge these constitutional reforms, I think, in a substantive way. And in fact, the whole debate in American constitutionalism, because of course, there are groups in the United States, there are legal scholars who challenge the you know, rights courts-based sort of stress in some traditions. So you know, some people call it popular constitutionalism, some people call it democratic constitutionalism. It's also what's sometimes referred to as political constitutionalism. That would be people like Waldron, maybe Tushnet. And all three of these groups argue that yeah, we've went too far over to the courts, right? That we don't have enough democratic input, but they also understand democracy in pretty much majoritarian terms. And they also kind of say, well, we have to kind of tilt it back over. Maybe not, of course, over the way Orban wants it, but so this whole debate, I think, certainly in American, maybe not so much in Canadian constitutionalism, but in American constitutional scholarship, recreates the dichotomy between rights and democracy, which I think plays into the hands of the kinds of arguments that are being put forward by populist constitutionalism. So I want to suggest a different route, and that is deliberative constitutionalism. So deliberative constitutionalism, also, it's a thing. I didn't make up the term. There are now 2 books out that are collections of essays on deliberative constitutionalism. This is, of course, a view of constitutionalism that is informed by theories of deliberative democracy. Theories of deliberative democracy, there's a lot of them, and they have, of course, family resemblances, but there are a lot of different ones, and so there are also a lot of different ways of understanding deliberative constitutionalism. The core idea is that you understand liberal democracy or liberal or constitutional politics in deliberative terms. I'm going to put forward and defend a view of deliberative constitutionalism that is heavily, surprise, surprise, heavily informed by Jürgen Habermas's work. In it, I'm going to say that there are 4 components. I'm going to defend it as having 4 components. Like the first 2 components are like totally Habermasian, and the second 2 components are, the third component is more like Simone Chambers reading Habermas, and then the fourth component is what I would consider some of the most cutting-edge work done in deliberative democracy, having to do with things like referendums and practicals. So the first is the co-originality thesis, in which, as we'll see, Habermas argues that you can't really separate democracy and liberalism. The second argument is really very important, and it's subjectless popular sovereignty. I mean, sometimes people call this post-sovereignty, but it's the idea that there's no one identifiable people, ever. And Habermas has a procedural view of that, so that and why this is really super duper important is because this shows that one majority can never represent the people. One election, one referendum, even though you might, can never actually articulate the views of the people, or carry the mantle of popular sovereignty and justification. The third argument is that in disaggregating and proceduralizing the notion of popular sovereignty and the people, the public sphere replaces the vote as the central institution of democratic legitimacy. You still have to have votes, of course, and votes are very important, but you think of votes as kind of punctuating a procedural system over time, that no one vote carries any kind of really really heavy-duty legitimation, but also, more importantly, it is the public context within which votes take place that is the most important thing. So having elections where you have no free speech is the simplest way, that is, of illustrating why you need a public sphere, but in this view, it becomes more kind of elaborate and complicated. And then finally, when you take these 3 together, the practical implication is that it really shows a picture, a potential of deliberative or democratic participation in constitutional reform, whereby the institutions and the practice or the participation is in some way safeguarded from majority capture. So at the end of this presentation, I'm going to talk about how you can think about referendums that are not, I know it's going to sound counterintuitive, but a referendum that is not a majoritarian instrument. It is instead a catalyst for a national conversation and so on and so forth. So those are the 4 parts. Co-originality, some of this, a lot of it might be pretty familiar by now. So Habermas's thesis of co-originality is both a theoretical thesis and also a kind of historical descriptive thesis over time. So it's a justification for modern constitutions, which says, look, you know, we've been sort of caught in this fruitless, I guess, you know, what comes first, rights or democracy, rights or democracy. They justify each other in this circular way. So if we want to try to, you know, if we don't want to rely on a natural right or a natural law argument, we have to really see rights as rights that are instituted as really justified through becoming the outcome of democratic procedures over time. And democratic procedures themselves only actually have the power to justify and legitimate rights if they're actually undertaken under the conditions of rights, right? So it is this co-originality, which he means it historically, that is, rights and democracy kind of developed together. But also he means it theoretically, that the only thing that can justify rights is the proper are discourses and democratic actions. But those can justify them only if they're structured in a certain way. The circularity is mediated by a theory of discourse. And the theory of discourse says, look, when we think about justification, not justification or anything in particular, but just the idea of justification, think about the structure of what counts as a justification. What's happened in the modern world is that we don't really have any collectively agreed upon buck-stopping arguments and justification. We can't go to God, we can't go to natural rights, we can't go to nature, we can't go to even consensus, right? So instead we kind of have to fall back on the procedures of justification itself. Like, what counts as justification? Well, if you had a conversation where everybody was equal and everybody finally agreed. So more and more we rely on trying to reproduce the conditions of justification, which gives us warrant, not certainty, but warrant, that the outcomes are justified. So he says we have to actually think about the relationship between democracy and rights kind of like that. That if we think about rights as actually creating the political structures for having open discourses which can test and argue and create a procedure of justification over time, then this will actually create conditions for justification. So the democratic will, it's not just willing, right? It's not just because I say I agree that justifies the outcomes. It's that I agree under certain types of conditions. So those conditions can kind of hook into this discourse theory of the conditions of justification. So that the outcomes are legitimate to the extent that you can see in our rights, in our constitutions, in our social structures, that you can see the conditions of equal discourse existent there for the outcomes. And so what you see in the end is that it's not just that you have liberalism and democracy that are mutually kind of reinforcing. It's that it's impossible to separate them, and that the conditions of discourse, or even the conditions of voting, are an essential part of what democracy is. And so this, I could spend longer on this, and I'm sure you're probably going to want to return to it. I actually do find this argument quite persuasive. I do think that it offers a view of the relationship between rights and democracy that really does show why arguments say, look, democracy is just majority rule, and lots of people say that, including not just populists, but Casamuda in his book on populism said, yeah, democracy is just majority rule. That shows that can't really be what democracy is, and that democracy, the primary principle of democracy is the equal status, or the equal and autonomous status of each and every citizen. That you cannot have democracy without that first. And majority rule or voting is one institutional articulation of that, but that's not the fundamental principle. The fundamental principle first is the equal status of every citizen. And I think that, and in the equal status of every citizen, that collapses liberal principles and democratic principles together at the first starting principle. And what this, so constitutional moments and constitutional reform, both foundings, but also reforms like, and amendments, right? These are part of a overtime process of bootstrapping. So no one, you can't say one vote or one referendum or one amendment has captured that moment of popular sovereignty, because no one moment can capture this ongoing process of reinforcing itself. It is a process that has to be evaluated over time. So the claim to say, aha, we got 51% of this, we have a huge majority, electoral majority, and a huge majority in Parliament, and this proves that we have the people behind us. Those kinds of arguments are completely undermined by this view. And so what this does is it changes the relationship between popular sovereignty and majority rule. And it argues that even though popular sovereignty, that is the people, are somehow the carriers of legitimacy, in evaluating whether or not your system actually is a system that adequately articulates or allows citizens to articulate their views, has to be evaluated over time procedurally, right? So you have to look at things like, of course you have to look at socioeconomic issues, but you also have to look at structural issues like the openness of the public sphere, the access to the public sphere, the circulation of information, the circulation of reasons, the relationship, the pathologies that are that you find in political communication. These are the kinds of questions that you look at. And what this leads to is a view of popular sovereignty and the people which is disaggregated. So Habermas uses the term, subjectless and sometimes anonymous view of the people, where no one point articulates the people, and that you evaluate peoplehood through procedural evaluation. This is a quote from Habermas. He says, popular sovereignty is no longer embodied in a visible, identifiable gathering of autonomous citizens. It pulls back into the, as it were, subjectless forms of communication circulating through forums and legislative bodies. Habermas also calls this idea of popular sovereignty autonomous and lacking, quote, overly concrete notions of a people as an entity and a communicatively fluid sovereignty. So one of the things that people love to cite in this debate about populism is Claude Lefort's idea that the people is an empty place, right? And one of the mistakes or one of the dangers or problems of populism is that they want to fill that up. They want to fill it up with a picture of the people and use that concrete view of the people to put forward certain types of and justify certain types of agendas. So Habermas does kind of embrace this idea of the empty space, but it's not completely empty, because then he makes a very sophisticated argument about the procedural rules and regulations and processes by which we can actually evaluate the health and even the existence of the exercise of popular sovereignty. And at the end of the paper, very shortly, I'm going to give a concrete example of that. Right. Okay, so what this does is it places the public sphere, broadly understood, in a important role. That is, the public sphere, in a sense, replaces or displaces votes. As I say, we have votes, we have elections, we have referendums, we need votes for all sorts of reasons. You know, but what now becomes important are the conditions under which votes are taken, and the kind of the circulation of reasons, and not only the circulation of reasons, even more important, the possibilities of dissent, opposition, and criticism within the public sphere, right? Because if you are evaluating now your democracy on its procedural grounds, right, and if those procedural grounds are being evaluated generally from a point of view of the conditions of justification, then what you want to be able to have warrant that the outcomes are solid, are dependable, you want to have as many voices as possible, you want to be able to answer as many criticisms as possible, you want to hear all the objections as much as possible. So you have to have an open, critical public sphere, which might, you know, sound chaotic, and it is often chaotic, but that is the condition of popular sovereignty. And that is exactly the condition that populists undermine, criticize, and try to avoid. That is, they see an open public sphere as an enemy to the articulation of the people's will, and as setting up roadblocks and opposition to the people's will. And it's in their undermining, and it's not just, you know, because of course we don't have perfect public spheres, right? Our public sphere in Canada, United States, is full of pathologies, and we can, you know, criticize it in all sorts of ways. But there's something more significant in the way the populist constitutionalists, because it's not just that they don't promote it, it's not just that, you know, they allow for regulations that create like radically unequal accessibility to the public sphere. They actively undermine it. They, for example, that there is a lot of press suppression, opposition going on in these public spheres. Some, you know, Venezuela is the worst, but actually Turkey and Hungary are pretty bad and getting worse. They, you know, fake news, what I call fake news, because it's the accusation of fake news, so it's the fake news, is a favorite accusation on the part of these leaders when it comes to opposition voices or minority voices or dissenting voices. So their concerted focus on undermining the conditions of the public sphere, I want to argue, is what is the telltale sign that their claim, that they forfeit the claim to be acting actually in the name of democracy. Yeah, so these are, dissent is the populist, the obstacle is always maliciously placed in the path of the will of the people. So what, you know, so I've been talking in kind of pretty general terms about, pretty general terms about this idea of a procedural evaluation of the public sphere. What would that look like in concrete terms? And so now, at the end of the paper, I just want to briefly bring up two cases and do some pretty down and dirty comparisons. If there are any comparative politics people in the room, they're going to be horrified by this, but I do hope to elaborate these cases in more detail. So the first case is the case of Scotland. So Scotland has decided to take up the issue of Scottish independence. And what they did was they were thinking through procedures. They knew that they were eventually going to have a referendum, but they really basically decided to start a conversation, like, you know, 5 years before they were going to have the referendum. And the government put in a lot of money, not in ad campaigns, but rather a lot of money to try to bring in civil society organizations to try to get the conversation going. So right away, there is a clear distinction when, for example, in Turkey, in the 2017 referendum, it's very clear that the referendum they're interested in the referendum for a mandate, for an agenda set by the elites. It's a very short period of time, the referendum campaign. The question is set, there's no, you know, and the question is set from above, and it is structured in such a way, a yes or no, to give a mandate, right, to a party that wants to that has an agenda, versus the way in which in Scotland this referendum was set up, it's first of all designed to be a catalyst for a conversation. So right away they understood that that would require not just the government, saying what do I hear, but actually getting the buy-in from civil society organizations, from churches to bridge groups, to all sorts of, and that takes time and it takes a lot of grassroots working. And by all accounts, there really was a national conversation. The actual campaign, the official date when they set the referendum, they had 18 months to have the campaign. And again, there was a lot of discussion and a lot of debate and a lot of buy-in. Everybody, was aware of it, and they also used this not just to focus on independence or dependence or independence, but to use this opportunity to talk about, well, how do we see Scotland in the future politically? What kind of democratic institutions do we want? Where do we see our, for example, immigration and identity? So they used this as an opportunity to have a national conversation about the future of Scotland. And in the end, of course, there was a referendum. It didn't pass. There was a majority-minority vote, right? But it's clear that the vote was simply the kind of endpoint or the catalyst to have the conversation. And the structure of the referendum was not focused on majoritarian instruments. It was focused on using the referendum. So the referendum, in a sense, the voting part got downgraded, and what got upgraded was the conversation. The vote was just, kind of catalyst for the conversation. And if you compare that to Turkey, where the use of referendums, as I say, is top down, it's the agenda is set, the question is set by elites, and it is entirely structured to give a mandate for a certain type of elite action. The second case that I take up is the case of Ireland. So one of the ways that referendums can be structured is to have citizen assemblies or mini publics prior as agenda setting. And in Ireland in 2013, they set up a constitutional convention. And constitutional convention was made up of 65% of citizens, and the rest was made up of parliamentarians, and the parliamentarians were from all the parties that were in the legislature, as well as 3 from Northern Ireland, which really didn't have to be there, right? But they, and they started with a narrow agenda, but one of the first things that they did was they opened up the agenda. And so that it was an agenda-setting institution, which then said, we really need to talk about this, and we need to take a decision on that, on gay marriage. At the first sitting, they did not talk about abortion. They talked about different structures of representation and so on and so forth. And then this citizen assembly then put the agenda that they had set into the public sphere, in which then after that they structured referendum. But the referendum, one of the things they did is they disaggregated it, right? So there would be one referendum on gay marriage, another referendum on representatives, and so on. And again, the entire structure, the entire institutional structure was really designed to try to get maximum amount of buy-in and maximum amount of national conversation about the future of these institutions in Ireland. If you compare the Constitutional Convention to the Constituent Assembly in Venezuela, which there have been a number, but there's this latest one in 2017. So on the surface, the Constituent Assembly looks like it is a democratic institution. But the problem is that only people from one party, the ruling party, were allowed to run for this. And so the agenda for what they decide in the Constitutional Assembly was already set by the party. And so what happens is that this Constitutional Assembly, it gives the impression of actually representing a kind of common consensus voice, because the outcomes, like what they decide in this Constitutional Assembly, has been, like the votes are like 95%. There's very little dissent. But what they did was that they excluded any kind of opposition at the design phase. So it was designed in order to further the agenda of the populist party, and not designed, like the one in Ireland, to actually elicit a conversation. So in both these comparisons, in the comparison of Turkey and Scotland, and the comparison of Ireland and Venezuela, you can see the way the exact same institution, in a sense, the first one referendum, the second one constituent assembly, democratic institutions can be implemented and designed in different ways. One, actually, I think, to promote democracy, as I understand it, and the other to undermine democracy by undermining pluralism, dissent, and the public sphere. Okay, and that's the end.
Thanks very much.